So I wanted to talk about some of the types of administrative agency activities that are actually exempt from California's APA. So you may recall that the Administrative Procedure Act, the APA, sets forth the rules that California's more than 200 agencies, departments, boards, and commissions that adopt regulations must follow. Now, this doesn't apply in all instances. Government Code Section 11340.9 specifies that the APA doesn't apply to an agency in the judicial or legislative branches of state government, so only the executive branch. It doesn't apply to legal rulings of council issued by the tax agencies, Franchise Tax Board, Board of Equalization, or California Department of Tax and Fee Administration. A form prescribed by a state agency or any instructions related to the use of that form, a regulation that relates only to the internal management of a particular state agency. The APA doesn't apply to regulations that establish criteria or guidelines to be used by the staff in performing audits, investigations, examinations, or any sorts of inspections, or for settling disputes, negotiating commercial arrangements, or in the defense, prosecution, or settlements of a case if such disclosure would result in certain specified occurrences. The APA doesn't apply to regulations that embody the only legally tenable interpretation of a particular provision of California law. The APA doesn't apply to regulations that establish or fix rates, prices, or tariffs, nor to regulations that relate to the use of public works such as streets and highways, when the effect of the regulation is indicated to the public by a sign or a signal. And the APA doesn't apply to a regulation that's directed to a specifically named person or group of persons, and doesn't apply generally throughout the state of California. So those are the 9 statutorily provided exemptions from the state APA.